Welcome to Thompson Coburn's presentation on the attorney-client privilege and its implications for in-house counsel. My name is Jeff Brown, and I'm a litigation partner in TC's Los Angeles office. I've had the pleasure of working with in-house counsel and some of you for over 30 years, and in that time I've learned various practical issues concerning privilege that in-house counsel concern themselves with, sometimes on a daily basis. I hope to discuss with you some of those issues that can be helpful to you in your daily practice in working with your business people and with outside counsel. I love this quote. 3 can keep a secret if 2 are dead by Benjamin Franklin. So the attorney-client privilege, as the slide suggests, sometimes is not as simple as we all wish it were. It causes confusion when it's available, when it's not available. Significant issues occur also when you're in-house counsel. Are you acting as a negotiator and a business person when you're communicating, or are you acting as counsel providing advice? So let's first talk about the privilege. In most states, for the privilege to apply, there must be a privileged communication between a lawyer and his or her client. For many of you, the client may be an entity, such as a corporation, partnership, or LLC. For purposes of conflicts, as you know, the employee may not be your client in terms of claims against the company, claims against individuals. But except for those states that have the control group test that we'll talk about in a little bit, communications with a company's employees may also fall under the umbrella of that privilege. California, and I'm a California lawyer, has the rule that communications between a corporation's employees and its attorneys, including in-house counsel, are privileged to the extent that the communications are within the scope of the employee's responsibility or the employee is a co-party with the corporation. Lucky for me, there is no control group test in California, so I don't have to worry about who I'm speaking with at the corporation. It becomes tougher, say, if you're in Illinois, because Illinois has the control group test. There, an employee is a member of the business's control group if the employee has an advisory role to top management. The decision would not normally be made without the employee's advice or opinion, and the employee's opinion forms the basis of any final decision by those with actual authority. Therefore, obviously, those lucky enough, and I say that in a sarcastic way, to be in a control group state for purposes of privilege have to take extra care when they're communicating with their people. In Illinois, the control group has 2 tiers of individuals whose communications with corporate attorneys are protected. 1, the decision makers and top management, and 2, employees who directly advise the first tier and on whose opinions the first tier employees rely. So obviously that second tier is the point where you're trying to investigate a particular matter, and because those people are the ones reporting to the upper tier. Just as an example, and everyone obviously has to look at their own state's law, Connecticut does not have the control group test. The attorney simply must be acting in a professional capacity. The communications must be made to the attorney by current employees or officials. The communications must relate to the legal advice. And the communications, just like all attorney-client privilege communications, must be made in confidence. In Delaware, there's no control group test. And in New York, also, the courts have rejected the control group test. In New York, the attorney-client privilege extends to communications with low and mid-level employees, as well as those in the control group. So let's briefly talk about what we're going to complete our conversation with. These are the issues that we'll discuss. Again, what I'm hoping with respect to the presentation is to key on some issues that you deal with on a daily basis or that may come up in your practice. In addition, it might trigger some issues and questions, and again, I'm available to just briefly talk about general issues if you have those kinds of questions. So we're going to talk about the role of in-house counsel. I already briefly discussed it. What hat are you wearing when you're giving advice, when you're having communication? The procedural process, a lot of people ask me, is there any magic in the privilege label? Does it give you protection just to say that? Next, sharing information. Two's company, three's a crowd. this is a waiver issue, obviously. What happens when you've got a privileged communication? Can you share it with others? Joint venture transactions or partnership transactions, how do you keep it in the partnership? Are the communications with your general partners, are they privileged, or does it lose it as between the partners or the joint ventures? Next, third-party reports. Can you turn a pig's ear into a silk purse? In other words, if something's not privileged to begin with, if you simply give it to a lawyer, does that somehow provide some type of protection? Next one is a real important issue for those doing deals, ownership transfer issues. Did you just sell your privilege? You had a transaction, your client sold the ownership interest to somebody else, now they own the LLC, the corporation, whoever, whatever it might be. Did all of your privileged communications just get sold to the new owners, and can they now break open that privilege and see exactly what you were talking about with your client? Last, in a brief way, we're going to talk about the government's role, what happens when the FBI or someone knocks on your door and says, hey, I want you to deliver some documents, what to do. Obviously, I'm not a white-collar criminal defense lawyer, which is the first advice I always give clients, is to make that call. But we'll talk briefly about what the courts have said about the privilege in that scenario. And then last, applicable law. Everyone here probably deals with transactions or litigation that involves more than one state. What do you do there? How do you focus? So the next issue that we're going to talk about is what hat are you wearing when you're in-house counsel? Again, in California, we're fortunate to have a lot of our clients in-house counsel to give our clients advice and to coordinate with us. Special rules apply that we've talked about briefly. They're not always treated for lawyers for purposes of the attorney-client privilege. And as you can see from the questions that are presented, are internal discussions among client representatives privileged if they include in-house counsel? If not, why not? And that often concerns itself with the determination of this wearing two hats phenomenon. In-house counsel a lot of times are simply giving business advice. They're the ones negotiating with the other side. They're the ones communicating with lenders, governmental agencies, things like that. In that situation, the in-house counsel communications are not privileged. On the other hand, when the in-house counsel is giving advice or seeking advice with respect to a legal issue, that is privileged. And oftentimes it becomes a little mushy about when one starts, when one ends. So what we need to focus on is what do you deal with and how do you deal with the situation when you're wearing those two hats. California has two good examples of appellate decisions that kind of help the thought process. One is called Chicago Title Insurance versus Superior Court. And in that situation, the defendant's in-house counsel was deposed as part of an investigation for fraud allegations. And the court noted that the in-house counsel's role were not typically those of either outside counsel or in-house counsel. The court held that they were so intertwined, in fact, with activities which were wholly business or commercial that there couldn't be a clean distinction between the two roles, and therefore, in that case, the privilege didn't apply. So it became so mushy for the court, and the counsel weren't able to explain to the judge that this was actual legal advice and not simply business advice, that the court said, sorry, I'm not going to let you have that as a privileged communication. Different with respect to Costco Wholesale versus Superior Court, there the court said, again, what we all know, that the privilege doesn't apply when an attorney acts merely as a negotiator or is providing business advice. But when a communication is both, which happens all the time, I'm sure, for in-house counsel, for the purpose of furthering the attorney-client relationship and the independent purpose falls outside of it, the court there said you look at the dominant purpose. Is it to further the objective of the attorney-client relationship? If that dominant purpose is yes, then the privilege is upheld. The courts in California, again, and everyone has to look at their own states of this, the good news for us here is that in-house counsel giving it legal advice can even extend to the lowest levels of employees in the company. And even if they have no direct contact with a lawyer, at least in California, in other words, it might be transmitted, forwarded information. Again, acting as a negotiator, we got to be careful. It's not privilege. So let's look at the practical points. What do we get from this, from the fact that you look at the dominant purpose, you got a problem with respect to intertwining. So it's really important when there are very important strategic conversations to be made that maybe in those situations when you're using outside counsel, you get the outside counsel on the phone. It makes it much more easy for the court later on to say, oh, this was a privileged communication. If the in-house counsel is the only one on the call, make sure that you confirm that everyone knows that you're giving legal advice, not acting as a business person when you do that. I know that's a difficult distinction to make. I know that might be time consuming, and I know that when I give advice to clients, they tell me, yeah, this will stop us from getting into trouble, but it also might stop us from ever getting a business deal done. So I recognize that there's a practical side of doing this, but to the extent that you can distinguish when you're giving legal advice versus acting as a business negotiator, please try to do that. Illinois has the spin because of the business, the control group issue, that you got to be careful there that you're not giving advice with respect to those outside the control group. And again, it's that same issue. Are you giving legal advice, or are you acting as some type of a negotiator? Connecticut, just as an example, you look at whether it's predominantly legal. Delaware gives the obvious thing that simply because a lawyer is present at a business meeting, cause to consider a problem that has legal implication doesn't mean that it's privileged. The privilege protects legal advice as opposed to business or personal advice. New York, again, the purpose has to be of obtaining legal advice. Communications won't be privileged where they are not primarily of a legal character, but actually deal with non-legal concerns. So this is a question that I get all the time because everyone says, well, there's a couple of things that people want to do, and we'll talk about them. One, people say, should I just put that everything that I send in terms of an email is privileged, and that way, you know, I can somehow create the attorney-client privilege. Or the other one that people do all the time is they say, well, why don't my business people simply CC me as in-house counsel on every communication, and that way we can argue that everything is privileged. So let's first talk about how do we protect emails, keep them confidential, and mark them as privileged, and what's the result if an internal client forwards an email in contravention of your advice not to do so. Also, should in-house counsel's email template include the language indicating that the email may contain information that is confidential under the attorney-client privilege or the work product doctrine that we'll briefly talk about today. First, what protection does one get from simply marking a document as privileged? And here, again, I think it's good advice to mark in the subject line of your emails when you're giving legal advice something like confidential, attorney-client privilege. Now, basically based on war stories, you know that a judge, if the judge sees every single email having that subject line or every single email having a CC to you as in-house counsel, the judge isn't going to buy that. What's going to happen is the judge won't believe you, and then we're in trouble in terms of trying to keep everything privileged. So you need to do it in a way that is more careful than simply marking everything as privileged. So it doesn't mean, though, that you shouldn't mark those that are sensitive, that have privileged information as privileged. I think it's a good thing to do. First of all, it does help us in litigation later on to explain to the judge, look, not all the documents were marked privileged. These are the ones that are marked privileged. You know, we have to usually give a privilege log that lists them, and it has to be from to with a little bit of what the matter is. And that's important, and that provides us with the ammunition to convince the judge that these were actually attorney-client communication. Interestingly, in California, the judge, for determining whether there is a privilege, isn't allowed to look at the documents themselves, isn't allowed to look at the emails. So we have to provide the judge with declarations that explain why, when you were sending an email to one of your business people, that you were, you know, basically giving legal advice and you weren't acting as a negotiator. Again, practical advantage during litigation, which sometimes can be years after these transactions or whatever you were doing with respect to your business people come up. You know, I get sent disks or emails with lots and lots and lots of emails. We have paralegals, as you know, that go through it to make it a little less expensive to deal with that expensive discovery process. And it makes it easier to pinpoint those that are privileged and to make sure they don't get produced to the bad guys in this situation. If it does say attorney-client privilege, confidential, something like that, something that keys us in as we're going through hundreds, if not thousands, of emails to produce to the other side. The other thing, too, obviously, is it really triggers this idea of inadvertent disclosure. This is a concept that has been developing in California and other states that is basically recognizing that we're in a world now where there's thousands, if not millions of pages of documents in litigation that are getting sent back and forth, and the mistakes are going to be made that something that was privileged was part of that DVD that was sent over to the other side. And what California courts have said is, look, if you are on the receiving end of all of these documents and you find something that looks like it might be privileged, the burden is on you now not to read it any further. So you see an email and you recognize, oh, that's a lawyer from the other side, in-house counsel or outside counsel that is on the to or from or CC line. I need to stop. I can't read it. And at that point, the obligation is on the receiving side. So the bad guys, the guys you're against, the obligation is on them to basically contact you and say, did you mean to send me that email, Bates number 123? The burden then shifts to the other side to say, oh, no, that was inadvertent. Please destroy it, you know, and there's practical ways where you either send new disks over or they get deleted, whatever it is. California courts are so strong in this situation that actually law firms get disqualified if they do gotcha and hold on to these privileged documents knowing that they're privileged and were inadvertently produced. In fact, there was one that was just on Law 360 of a large litigation that a big firm was disqualified, where the judge said, you basically knew that this was a document that was privileged, that was inadvertently produced. You waited till somebody's deposition, and then you did gotcha. The court said that you're now going to be disqualified. So it does provide some level of protection. It does allow us, you know, as we go through the process of litigation, you know, which nobody particularly likes, to go through and be a little more efficient and be a little more careful, because you're actually seeing subject or ray lines that say privileged. That's why that's really important. Now, speaking of inadvertent disclosures, and this is something that I've had a bunch of times. I'm sure you have. If we were in the same room, I could do by a show of hands, how many of you had this situation? It's that you have sent your client your legal advice. It says on the subject line, attorney-client privilege. You've done everything right. You even add the famous please do not forward, which I've done a lot, to make it really clear to some of your business people, please keep it here, don't send it to anywhere else. And invariably, what happens, you find out that your business people have sent it to somebody else. They sent it to the other side. And so you find out either from counsel for the other side or just your business people finally say, yeah, I tried to convince the principals on the other side of why we're right. Well, how did you do that? Well, I sent them your email. It was a really good email, Jeff, that it explained all the legal issues here and why we should win. So I thought if I send it over there, maybe we could cut through all this litigation expense and time, and we could convince the other side. That happens all the time. That takes some training with respect to your inside business people. When litigation hits, one of the things that I like to have a discussion with in-house counsel, say, look, there's going to be a lot of discussion now that there's litigation. I can either send you or you could send to everybody inside that's involved with this. There is litigation. Please don't send any more emails to each other. They won't be privileged. If you need to communicate and send it to you as the in-house counsel or to Jeff as the outside counsel. And please do not forward information that I'm sending you as inside counsel or that Jeff is sending you directly with CCs and me to anybody else. If you have any questions, if you think somehow that it would be good to send some of that information to the bad guys in this litigation, then please give me as the inside counsel first a call so that I can tell you why you shouldn't do that. One of the things that happens a lot too in terms of forwarding is the idea that you've sent a very simple email to one of your people saying, this is why I think the transaction should be this way from a legal standpoint, or some of the issues about why the transaction should be this way or why the litigation is going to go this way, and here's some of our defenses, here's some of our claims. And the first person who saw it obviously sees that it's privileged. But then what happens is people within the company, especially when there's a lot of people involved in either the deal or the litigation, start forwarding it back and forth, and then people add things, and then all of a sudden your privileged information is at the bottom of 10 forwarded emails, and now everyone forgets that there was privileged information at the very beginning, and that can be a little bit dangerous because then it could be an inadvertent disclosure later on. So again, I think that's one of those things just to keep track of during a deal, during litigation, that hopefully stuff like that doesn't happen. I do like, by the way, the template when you're in inside counsel saying, look, this email may contain privileged information and work product. You know, if you got it by accident, please delete it and let me know. Okay. So finishing up this topic, let's just talk about, as a side note, about the work product doctrine. Obviously, that's different in states. You got to be very careful. California basically doesn't make a distinction between the attorney's work product, whether there's litigation or pre-litigation, or whether you're doing a transaction. There's protection for that, which is terrific for deal people. However, the federal rules in other states require that there be an anticipation of litigation. Because of that, you just need to be careful in terms of what your work product is. The difference, you also know the difference between work product and attorney-client privilege is while the client holds the privilege for attorney-client privilege, the attorney work product doctrine is it's held by the lawyer. Next thing we're going to talk about is more with respect to waiver issues. Three's Company, let's try that again. It's not a TV show. Two's Company, three's a crowd. And we're talking now about sharing information. The idea of you had a privileged communication. What happens if you bring in other people? Does it kill that communication? Again, another war story, show of hands. How many times have you gotten on a call with your business people to discuss the issues with respect to a transaction or litigation, and then you found out later in the conversation, because all it says is conference, that your business people also had the other side on the call, and or a third party on the call, and you didn't realize it. So if the third party's on the call, you got a problem because you may have a waiver with respect to that. And if the adverse party is on the call, that's even worse because they're getting all of your advice and potentially results in a waiver of a subject matter waiver, which is even broader than the communication. So that's something that's happened to me quite a bit. I learned after the first couple of times where first thing I say when I get on a conference call is who is on the call to make sure that there isn't any third party, especially someone on the other side of a transaction. Sometimes I get called in during the negotiations of a transaction because of litigation types of issues such as ADR provisions, reps and warranties, indemnity issues. And so always ahead of time you want to make sure that the in-house counsel, and you as the in-house counsel and others understand who's on the call so you don't end up with a waiver. So California, though, has kind of a broader, as you'd expect, because we're all about protecting things here, protecting the attorney-client privilege. It's called a common interest doctrine. A lot of other states have it as well, but basically the concept here is that if a lawyer needs the advice of a third party, a consultant such as a broker, accountant, or even a translator, that to give advice to his client, in other words, it's needed to for the lawyer to give that advice, then the argument under California law is that there is no privilege that has been waived. In other words, there's no waiver. So one of the cases looked at it and said, look, a disclosure in confidence of a communication that's protected by a privilege when disclosure is, and here's the words, reasonably necessary for the accomplishment of the purpose for which the lawyer was consulted, is not a waiver. Therefore, when there's an involvement of an unnecessary third party in attorney-client communications, that destroys confidentiality. But if you're reasonably necessary to bring that person in to help you provide the legal consultation, the privilege survives. There is no waiver. And everybody has dealt with that in the past, I'm sure, and deals with it on a daily basis. It's the idea your client has asked you advice about a damage calculation with respect to litigation that's going on. You brought in a consultant that you haven't designated as an expert witness yet. The consultant is helping you analyze the damage numbers, either the claim by the other side or your own. That would be privileged when you've got everybody talking about that. It also has a work product component as well, obviously, because a lot of times the lawyer is the one who engages the consultant. Same thing, you've got a situation where you're about to acquire some commercial real estate. You've hired an environmental consultant. Again, as a consultant, you've got conversations that are going on. The consultant is helping you provide the legal advice to your client. There is no waiver there. Same thing with accountants, same thing with brokers. Illinois has a wrinkle here again because of the control group issue. Basically, anybody who gets information that's not within the control group, that's outside of the control group, the privilege is destroyed. So I guess what you could end up with is you got people in the client side who are in the control group, so you've got the privilege there, but you got to be very careful, because if the independent consultant's not part of that control group, and how could it be, you're going to have difficulty and you're going to have to be very careful there. And so maybe what you want to do as a practical matter there, and again, talk to your Chicago or Illinois counsel, is the idea of perhaps the lawyer is the one who uses the work product privilege to get the information from the consultant and then forwards it, by way of, conversations with the client, and therefore try to keep the privilege that way. Other states like Connecticut, they also have this idea of a common interest doctrine. If it's necessary for the consultation, it doesn't destroy the confidential nature of the communications. Delaware, basically the same thing. New York, the same thing. Basically, in New York, the attorney-client privilege extends to documents generated by consultants, retained by counsel, to assist in analyzing or preparing for anticipated litigation. So that's an interesting twist there. The scope of the privilege is not defined by the third party's employment or function under New York law. However, it depends on whether the client had a reasonable expectation of confidentiality under the circumstances. Now, one thing that I really focus on a lot when I'm dealing with helping people in transactions before the deals are actually done is something called a common interest or a joint defense agreement. In California, that developed over the last 10 years. Other states have it as well. And basically, everyone remembers from law school the joint defense agreement in the criminal context. They're co-defendants, and in that situation, they're both being prosecuted, and a lot of the states, including California, said, hey, if the confidential information from one co-defendant is shared with the other co-defendant with the idea that they have a common interest, and what's the common interest? Not to get convicted, then if all else being equal and there's no other waivers, that is a situation where there is no waiver. California, in about the last 10 years or so, has now moved on from using it simply in the criminal context and now uses it in the civil context. And one of the big cases that, if you ever look at this issue in California, is called Oxy Resources California versus Superior Court. And in that case, the court held that a joint defense agreement that was entered into between the parties negotiating a business transaction can block production of privileged documents to third party who is an adversary to both. that is really a powerful tool. You're basically in a situation where you're representing one of the joint venture partners, and you're obviously adverse to the other potential joint venture partner. You're in the process of negotiating the LOI, so early in the process. And what is the joint venture going to do if it is accomplished? It's going to acquire property, it's going to get a loan, it's going to have to deal with a governmental entity with respect to potential environmental contamination, millions of different things why you could be adverse to that third party, and you have a common interest with your adversary. And the court in California, and it's been upheld since, basically said, because you have a common interest, we're going to allow it to be applied to civil proceedings as well. So I often suggest to people to include a common interest agreement in their transaction. Now, when I drafted it, of course, it's 2 pages, single space, that has everything about non-waiver of claims against the joint venture partners, and what happens when the common interest agreement dies, and all sorts of things. Typically, the deal people don't like the 2 pages to begin with. Maybe they'll put it somewhere, shortened version in the actual joint venture agreement. But even a shortened version of that, a paragraph that basically says, hey, we intend to discuss privileged information among ourselves with respect to this third party, either because we know somebody else is potentially coming after us for purchasing the property, or the government is looking at us with respect to the property, or whatever the transaction is. So I like to tell the deal people, throw in a paragraph that says, look, we have this common interest with respect to these third-party issues that include the following, Bing, Bing, and Bing, and that way you have evidence that you are doing that. Do you, under the case law, need something in writing? No, the case law hasn't said that. But is it really helpful for litigators like me later on to try to demonstrate that there wasn't a waiver? You better believe it. If I've got a common interest agreement that says we're not waiving the privilege, we have a common interest as against that third party, it is very helpful in litigation issues. So what I basically tell people, throw up a paragraph in your LOIs, then in the more formal agreement, again, perfect world is that you use a lot more language that I would want to put in there. But again, it depends on the deal. So that's what we have in terms of California and this common interest agreement. The common interest rule is elsewhere as well, though. In Connecticut, the courts there have said that the joint defense privilege, also called the common interest rule, is an extension of the attorney-client privilege that protects communications between parties and the party's attorney when the parties have decided upon and undertaken a joint defense strategy. They're talking about in litigation. So they might be limited in Connecticut that when you are one of co-defendants in a civil litigation, you still may be able to put together a joint defense agreement. And by the way, obviously, and everyone knows this, when you do get involved in litigation, if you are co-defendants with someone who has a consistent position that you do with respect to those on the opposite side of the versus sign, then yes, that is a situation where you have a joint defense agreement. And because there's litigation, that's when you do use my 2 or 3 page big, fat, common interest agreement and joint defense agreement, because there's just so many issues there in terms of you don't want to be waiving your right to go after the co-defendant. You don't want to say that the other attorney is actually your attorney and creating conflicts of interest. So there's all this kind of language that you would want to put in there to protect yourself. Delaware has a built-in common interest privilege, so long as the clients share a common interest sufficient to justify invocation of the privilege, same thing. Again, New York requires there to be pending or anticipated litigation. California, because we love everybody, again, there's no litigation required, no anticipation of litigation. It can be a deal. It's simply a deal situation. One thing to consider, and it's an obvious point, but one of the New York courts says, look, just because you're entering into a cooperation agreement which they call as a common interest agreement or joint defense privilege agreement, doesn't mean that it miraculously or magically transfers everything that wasn't privileged into a privilege. These are waiver types of issues. So there has to be a privilege established before we look at these issues and the sharing of information. You can't turn something that wasn't privileged into something that was privileged, but you can try to protect it. And again, that's very efficient for litigation or for deals. You know, your joint venture partner already looked at the tax ramifications of the transaction. You don't want to have to spend the money again to do exactly that same work. If again the idea is that, oh, well, the county assessor you're both adverse to, let's figure out a way to do a common interest agreement so that we protect ourselves while at the same time saving some money. Now again, the answer, as a lot of times, may be different under California law. They may have less luck establishing the privilege under federal law. Again, you want to take a look at this this situation where you are and what your state law or federal law situation is. And again, the issue is, you know, it's easy when you're in litigation to know what privilege applies and to guard against disclosure because you have all these attorneys helping you go through the process. But for transactional lawyers, it may not be till well after the fact that an adverse party will seek discovery of your emails that you assume to be privileged, and might be a surprise to you that that's happening. That's why we got to be really careful about that. And again, you know, you got to especially be careful when you're in a control group test state like Illinois to make sure that you've got everything privileged to begin with, and that sharing of that privileged information doesn't somehow create a waiver. We're going to now talk briefly about keeping it in the partnership. Again, in partnerships and joint transactions where lawyers are giving advice to both 3, 4, all of the partners or all the joint ventures, that situation, all partners, at least under California law, are entitled to the wide range of information, of partnership information. So you've got to be careful there that if you're talking with your lawyer about your particular issue, that it doesn't, that you have a different lawyer than the lawyer who is giving advice with respect to the partnership or to the joint venture, because that may be something where there is no privilege even to begin with. Even more concern, of course, is in Illinois says that, you know, in that situation, when there's that waiver that the joint ventures or the partners should be provided all the information that the partnership or joint ventures lawyers give, that might be a subject matter waiver, which means it's not just that communications, it's everything having to do with the subject of that communication. And again, the Illinois court said there's no reason to distinguish between a waiver occurring during the course of litigation or during a business negotiation. So again, need to be very careful. Okay, we're going to now talk about, can you turn a pig's ear into a silk purse? And basically, first, and very importantly, I went to Wiktionary to figure out what that even means. And it basically means to produce something refined, admirable, or valuable from something which is unrefined, unpleasant, or of little or no value. For those learned, you know that it was apparently coined by Stephen Gosson in 1579. The concept here, of course, is that if you got something that's unprivileged, such as a consulting report, does it become privileged if given or obtained by your lawyer? And the answer is, as you would expect, no. You can't turn something that's not privileged into something that's privileged, like I said before, just by giving it to your lawyer. And the exception to that, and Illinois follows that same rule, but the exception to that obviously are the issues that you deal with about work product doctrine. The work product doctrine, and everyone probably has dealt with this, is you need to get a consultant for a deal or whatever that might be, so you get an outside consultant. You have the lawyer engage the consultant because you want the court to understand that the consultant was being engaged to help the lawyer, whether it's inside counsel or outside counsel, provide legal advice to his or her client. And so in that situation, I've made that argument to the courts lots of times where the consultant is, hey, that's privileged by work product. So that's kind of how you want to deal with that situation. One thing to keep in mind, though, is the idea, and this comes up in California, which has a very strong and broad duty to disclose situation with respect to the selling of real property, is what happens, you're the seller, you go and you get a phase 1 environmental report, it comes back not as good as you would want it to be. You had your lawyer, or you got it because you wanted to keep it confidential as work product. What happens now with respect to your duty to disclose as a seller to a potential buyer? And that's obviously on a fact-by-fact basis, but my concern in that situation where you have a state law that is so broad with respect to the duty to disclose that you probably won't want to take that chance of withholding the consultant's reports. And again, I'm talking in a very, very general sense. Obviously, the facts and the law for every state have to be looked at, because here's the downside. You withhold it, and then some judge says you shouldn't have withheld it, and now you've got to give it to the other side. And if you haven't disclosed those issues, that might be a big problem with respect to the failure to disclose laws, which involve, as you know, both a negligent failure to disclose, a contractual failure to disclose, and then also potentially unfortunately, a fraudulent failure to disclose. So again, it's a very important issue to discuss with your counsel and before you make a decision in that scenario. Delaware law, not surprisingly, has the same focus, which is that if something's not privileged, it doesn't become magically privileged when you give it to a lawyer. Again, and here's kind of what some people we've talked about before, the quote, imagine a firm that decides to run all of its communication through counsel. The first part of the document's privileged general counsel is answering questions. Then it says, by the way, boss, here's a report from the sales unit. The court said, yeah, that's not going to happen. That's not going to be privileged. And again, New York, similar, saying the attorney-client privilege can't be used as a device to shield discoverable information. Let me now go to, did you just sell your privilege? This is a big, big issue that I've dealt with lots of times, in that anyone who is in the transactional side of this and in litigation as well is a real important thing. It's the idea that when a company is sold, or actually whether there's mezz lender and that mezz lender forecloses, what happens to the company's privileged information? Will the company's lawyers be answering to the new owners of the company? And what if there's a foreclosure of the mezz loan? Now there's new owners. Does the mezz lender now have access to all those privileged communications? Who has the rights? And the answer is that the new owner has the rights unless the transactional people do something ahead of time that we'll talk about. California, basically says, look, after a merger, the attorney-client privilege of the corporation no longer in existence belongs to the successor corporation. Excuse me. So the former management of a merged company doesn't hold that privilege anymore and may not waive it, but obviously also means that the new owners of the company through the merger have that ability. Same thing with respect to a successor situation. When there's a successor to a corporation, there's no longer in existence, the privilege becomes the holder of the new corporation. That doesn't apply generally, at least under California, to the sale of the corporation's assets. That doesn't necessarily create a transfer of the privilege. New York says when control of a corporation passes to new management, the authority to assert and waive the corporation's attorney-client privileges passes as well. Again, New York says if you just sell the assets with no attempt to continue the pre-existing operation, that doesn't create the transfer of the privilege. Delaware hammered a corporation and basically said, look, a surviving corporation in an acquisition is the one who gets the privilege. So then what do we do? What do we do so we don't end up with all those emails that you sent to the former owners giving advice as to what to do in that transaction, including problems with our side of the coin, you do a carve-out. And I'm sure all of you have thought about this, but it's just very important. And in fact, the Delaware court tells people what to do. They said, thus, the answer to any parties worried about facing this predicament in the future is to use their contractual freedom in the manner shown in prior deals to exclude from the transferred assets the attorney-client communications they wish to retain as their own. Again, carve it out. Same thing with respect to mezzanine financing. If the mezz lender forecloses without anything in there, the mezz lender makes a really good argument that as the new owner of the LLC, the corporation, whoever it might be, that the mezz lender is the new owner, and the mezz lender is the one who can now take those attorney-client privilege communications that you thought you had with your now former client because of the foreclosure. Again, one of those things to really keep in mind. Hopefully you're already doing that, where you do a carve out, and so you don't end up with that situation. The government's role, stop in the name of the law, in effect. You probably heard of these situations about 5, 10, 15 years ago where corporations were being investigated by the SEC, Department of Justice, and then they would engage outside counsel to do an internal investigation, and then the feds or the state agencies say, well, you know, we have these rules that basically say if you cooperate with us, we'll be a little bit more lenient with our prosecution of you. And sometimes that cooperation means you give us those internal investigations, even though the internal investigations were intended to be privileged, at least in the beginning. And then there's a series of lawsuits all around, because what happens after you give it to the governmental agencies, invariably you have those class actions that come up within days of that, and now you have civil lawsuits. And so the argument by the civil plaintiffs firms are, hey, you waived the privilege with respect to those internal communications, those internal investigations, and therefore, and you can't have a waiver. I mean, you can't say, oh, I gave it just to the governmental agency. You waive it once, you waive it all times. The Ninth Circuit, where I am, basically says that you're right, there's no such thing as a selective waiver. In other words, if you give it to one, you can't then tag on a confidentiality agreement and say, hey, but I'm not intending to waive it for any future class action stuff. You waive it, you waive it. But what California basically said is, look, if you're coerced to give up those kinds of things, and in those days, you know, the coercion was, do you want to go to jail or do you want to give me your internal investigation? In those situations, the California courts have said, when as a matter of policy, the federal government advised corporations under criminal and regulatory investigation that they might avoid indictment or regulatory sanctions if they fully cooperated in the government's investigation and, among other matters, waive the attorney-client and attorney work product doctrine, that threat meant that it was a coerced disclosure, and therefore there was no waiver. California basically has one of its evidence code sections about privilege says, look, a waiver is when it's without coercion, so that's what the court focused on. There was a similar case that happened within a couple of years of that also in California where there wasn't a coercion, or at least the trial court and the Court of Appeal didn't find there was coercion, and because of that, the court found that internal investigation to be waived in terms of privilege. I took a quick look over the last couple of weeks, and it looks like the DOJ and SEC have relaxed that policy. But again, this is why the first point, as I mentioned in the beginning, is you go and get that white-collar defense counsel so that to team with us to help you in the situation, because they're the ones who do best with respect to negotiating with the governmental agencies. And obviously these are very important issues. This is all over the map, and literally and figuratively, in terms of how states look at these things. A lot of them have governmental interest. Hey, the privilege is something that we really look at very carefully, and we want to observe in our state and look at it from our state's perspective. So you really need to figure that out when you're doing a deal. Obviously, when you're doing litigation, it's mostly too late. You're now having to analyze the facts that are already in place. One thing to consider then, and legal people do this all the time, obviously, for other issues, is a choice of law provision. And the question then becomes, is this a public policy issue that a court would look at the choice of law, let's say California, New York, somewhere else, or Illinois, and say, well, we're not going to allow the choice of law provision for public policy purposes because of our view of the attorney-client privilege. Again, it's something that is very important to keep in mind as you're drafting some of this. If you have any general questions or wish to talk about specific things, please give me a call. Obviously, you can find me on the web, our website. Also, I have a California real estate blog that you might be interested in. Thank you very much.